Responsibilities of employers in preventing sexual harassment at the workplace. There are two complaint procedures applicable to employers under Alberta legislation, one under Occupational Health and Safety and one under the Human Rights Commission. Occupational Health and Safety. The Occupational Health and Safety Act places an obligation on the employer to maintain a healthy workplace, which is free from harassment, hostility, and discrimination. What does the Occupational Health and Safety legislation in Alberta say about sexual harassment at the workplace? The Occupational Health and Safety legislation in Alberta, specifically the Occupational Health and Safety Act and the Occupational Health and Safety Code, describe harassment and violence as workplace hazards. One of the listed purposes of the Occupational Health and Safety Act in its Section 2 is the promotion and maintenance of the highest degree of physical, psychological, and social well-being of workers. Section 3(1)(c) of the Occupational Health and Safety Act places an obligation on an employer to ensure that none of its workers are subjected to or participate in harassment or violence at the worksite. The Occupational Health and Safety Code defines violence at the worksite or work-related as the threatened, attempted, or actual conduct of a person that causes or is likely to cause physical or psychological injury or harm. Physical violence includes physical sexual violence and is punishable under the Criminal Code of Canada. In Section 1N of the Occupational Health and Safety Act, harassment is defined as any single incident or repeated incidents of objectionable or unwelcome conduct, comment, bullying, or action by a person that the person knows or ought reasonably to know will or would cause offense or humiliation to a worker or adversely affect the worker's health and safety, and includes conduct, comments, bullying, or actions because of race, religious beliefs, color, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, gender, gender identity, gender expression, and sexual orientation, and a sexual solicitation or advance, but excludes any reasonable conduct of an employer or supervisor related to the normal management of workers or a work site. Filing OHS complaint. If an employee is experiencing sexual harassment at a workplace governed by Occupational Health and Safety, OHS law, the employee can report the situation to a supervisor who can then communicate the information through the appropriate reporting line and deal with the issue in accordance with any internal processes. There is a difference between filing a complaint under OHS law and reporting unsafe work practice such as harassment and sexual harassment. Filing a complaint under the OHS law is a formal step and process. Where a complaint is filed, the organization's workplace hazards are reported to the Alberta government, and this would result in the government investigating the workplace hazard that has been complained about. The OHS code obligates an employer to investigate any incident of harassment or violence, take action to address the incident, as well as prepare the investigation report, which clearly outlines the incident and steps taken to address and prevent them from happening again. The employer must not only prevent the incident from happening again, but must develop and implement workplace harassment and violence prevention plans and policies. Filing human rights complaint. An employer is under a legal obligation to prevent the occurrence of sexual harassment at the workplace. The Alberta Human Rights Act prohibits discrimination in 5 areas and on 15 protected grounds. One of those grounds is gender. Harassment is discrimination and is any unwelcome or uninvited conduct that can be physical, verbal, or nonverbal. Sexual harassment is considered harassment on the grounds of gender. Employers have a legal duty to prevent and remedy incidents of sexual and gender-based harassment. When a person believes that she or he has been sexually harassed, she or he should try, where possible, to resolve the problem through any internal policies or resolution mechanisms the organization may have in place, although this does not take away their right to file complaints and seek resolution through other external means. Some organizations are unionized and have collective agreements which specify steps for preventing and resolving discrimination and sexual harassment in the workplace. In such instances, an employee may be able to file a grievance about sexual harassment under an existing collective agreement. What is expected of an employer if a complaint of sexual harassment at the workplace is made by an employee to the Human Rights Commission? Sexual harassment at a workplace creates a toxic or poisoned work environment. The Alberta Human Rights Commission has stated that a poisoned work environment is created when a workplace is hostile or unwelcoming because of insulting or degrading comments or offensive actions aimed at an employee or others. An employer is required to investigate a complaint of sexual harassment at its workplace promptly. The Alberta Human Rights Commission prescribes that an employer who neglects to follow up on a complaint of sexual harassment may be liable under Alberta Human Rights Act for failing to take prompt and appropriate action. An employer needs to ensure that the investigation is impartial, timely, and unbiased. The employer should check in with the harassed employee and offer any appropriate support to the victim. If the allegation involves assault or violence, the employer can encourage the employee's efforts towards informing the police. Can an employer retaliate against an employee for making a complaint of sexual harassment? No. According to Section 7.1 of the Alberta Human Rights Act, no employer shall refuse to continue to employ any person or discriminate against any person with regard to employment or any term of employment because of gender. Further, Section 10 of the Alberta Human Rights Act makes it illegal and against the law to punish or retaliate against an employee who has made or attempted to make a complaint under the Act. This provision applies to the employee who suffered the sexual harassment and to any witness who makes a complaint on behalf of the harassed employee. The Alberta Human Rights Act provides balance by prohibiting frivolous or vexatious claims or complaints. What can an employer do to prevent sexual harassment at the workplace? The Occupational Health and Safety Code clearly states that every employer must develop and implement a harassment prevention plan and violence prevention plan at the workplace and must develop harassment prevention and violence prevention policies. Below are some additional actions an employer can take to make an organization safe for its employees. Understand an employer's obligation with respect to violence at the workplace. Conduct regular periodic risk assessments to determine if workplace conditions are poisoned or toxic. Develop harassment prevention and workplace violence plans, policies, and procedures and ensure implementation. Educate all employees about the policies and make them easily accessible. For example, on notice boards, staff handbooks, onboarding documents for new employees, shared drives, etc. Provide training about sexual harassment for staff. Organizations like the Alberta Civil Liberties Research Centre, ACLRC, can provide this informed training for organizations. Fulfill legal obligation of duty to accommodate to the extent of undue hardship if an employee has requested for it. Example, providing a gender-neutral washroom. Display notices of no tolerance of harassment and discrimination in conspicuous places where public or customers can readily see them. Do not be dismissive of complaints. Rather, investigate complaints of harassment and maintain confidentiality of complainants as much as possible. If there is physical harassment, call the police. If allegations of harassment are proven, administer consequences as relevant and outlined in policy. Put measures in place to prevent a repeat occurrence. Review policies and plans every 3 years. My supervisor sexually harassed me. Can I hold my employer responsible for this? The Supreme Court of Canada in Robichaud v. Canada Treasury Board stated that an employer is legally responsible for harassment in the course of employment, including by supervisors, co-workers, and others. Example, clients. And a discriminatory practice by an employee should be considered a discriminatory practice of the employer as well, regardless of whether the employer authorized such practice. Some consequences of sexual harassment at the workplace. Sexual harassment at a workplace may result in financial and non-financial costs. Some of the consequences of sexual harassment at a workplace include: an employer is legally liable for harassment at the workplace. Low morale of employees. Mental health issues, for example, stress and anxiety. This can negatively impact both the employer and the employee. Poisoned or toxic work environment. Increase in absenteeism. Employees work better in a safe environment. Huge turnover of employees. Revenue loss, which may lead to business collapsing. It costs a lot more to hire and train new employees. reputation risk and loss, and negative publicity. Bad news spreads fast, and a good reputation is important currency for an organization. Legal costs, including settlement costs. Hiring the service of a lawyer may not come cheap. There are established principles for damage assessments when it comes to the issue of harassment, and these border on the objective seriousness of the conduct and the particular effect on the complainant who experienced it, as stated in the Alberta case of Walsh versus Mobil Oil Canada. For example, in the case of Manziak versus Taste of Tuscany Limited, the Alberta Human Rights Commission awarded $15,000 as damages for sexual harassment. When determining damages to be awarded for sexual harassment, some of the factors that the tribunal may take into consideration were stated in the case of Torres versus Royalty Kitchenware Limited and includes 1. The nature of the harassment, that is, was it simply verbal or was it physical as well? 2. The degree of aggressiveness and physical contact in the harassment. 3. The ongoing nature, that is, the time period of the harassment. 4. The frequency of the harassment. 5. The age of the victim. 6. The vulnerability of the victim. 7. The psychological impact of the harassment upon the victim. Conclusion. Prevention is cheaper than redress for an employer when it comes to the issue of sexual harassment. This can be implemented by having a sexual harassment prevention policy in place, which clearly states an organization's policy on the topic. An employer is liable for its employees' actions, so they should ensure that all employees are aware of the provisions of the organization's sexual harassment policy. The Alberta Human Rights Commission has stated that having an effective sexual harassment policy in place can decrease an employer's liability if a human rights complaint is made. Prompt and appropriate action on sexual harassment complaints can reduce an employer's liability still further. In some extreme cases, sexual harassment will be criminal in nature. This will be the case where the harassment involves attempted or actual physical assault, including sexual assault, or threats of an assault or even rape. It will also include situations of stalking, otherwise known as criminal harassment. Criminal harassment is obsessive behavior directed towards another person. Section 264 of the Criminal Code defines criminal harassment as repeatedly following a person from place to place or repeatedly trying to contact that person over a period of time. Behaviors that are criminal in nature also include watching over an employee's home and threatening people known to the victim of harassment. Employers may also include in their policies that if an employee reports a complaint of criminal harassment to the employer, they would be directed to contact the police. There is a sample harassment prevention policy available on the Alberta Human Rights Commission's website that an organization can adopt and modify for its purposes. Also, the Alberta Human Rights Commission staff are available to help an organization with developing a sexual harassment policy.